You're listening to Legal Sounds, Practical Advice for SMEs, the podcast from Davis Blank Furness.
Hi, welcome to a new business podcast series from Davis Blank Furness, one of Manchester's longest established and friendliest law firms. I'm Andy McNish, a solicitor and partner in Davis Blank Furness. I've 35 years' experience of helping business owners navigate all sorts of legal issues and will be your host for the next 30 minutes.
Today's topic is shareholder agreements. And I suppose the question is, what are shareholder agreements and why are they important? Well, there are contracts made between the owners of a company, the shareholders of a company, and they're important because they sort out what would happen to your business if the owners fall out or leave or die. And a good shareholder agreement should make a dispute less likely, as it clearly sets out how the business is run and the owner's respective rights. The default position under company law is that effectively the person or people who can get a majority of either places on the board and or shares are the people who control the company. Quite often in small businesses, if this is a one person band, or just one owner or a sole owner, or perhaps two spouses that jointly own the shares and the directors of a company, then there isn't very much need for a shareholder agreement. But once you introduce a scenario where there are minority shareholders, then you have to start thinking about minority shareholder positions. And for example, if a minority shareholder wants to leave a company and sell their shares, there's no right to do that under generic corporate law. There's also no right for an owner, a majority owner, to force a minority owner to sell their shares back to the majority. So with that in mind, unless you deal with it either in the Articles of Association or in a separate contractual agreement, there can be problems arising if somebody leaves the business but wants to keep their shares, or someone wants to exit a business and can't get rid of their shares, as an example. So my colleagues today with me are Lauren. Would you like to introduce yourself, please?
Hi, my name is Lauren Sever. I'm a partner in the corporate commercial department, and I frequently deal with drafting shareholders agreements, articles of association, and all the sort of ancillary documents that accompany those.
Hi, I'm Andrew Ryan. I'm a dispute resolution partner in the firm. When I deal with shareholder matters, it's usually where there's a dispute. It's all gone wrong, and everybody's fighting each other. So during this podcast, I'll give some feel as to what can go on in those sorts of disputes.
And I think it's fair to say that that can be a very expensive and protracted and quite vicious process.
Well, I think so. I mean, in fact, I know so. I think there's many judgments of courts where judges have said themselves that shareholder disputes are amongst the most expensive forms of litigation there is, and there's no doubt that is true. So I think there is a benefit in listening to this podcast and trying to work out how you might avoid being a client of mine in relation to a shareholder dispute.
I suppose just by way of introduction, that one of the important things, one of the benefits is a meeting of minds, because quite often if we're in a scenario where we're talking about something called a quasi-partnership, where you've got 2 or 3 or 4 people starting a business together as equal or co-shareholders in a business, or in some manner, and they're interested in driving the startup or driving the new business forward, and they all want success of the business, and they're all keen to get going, and they often think, well, shareholder agreements, that can wait. They cost maybe a couple of £1,500, £2,000, whatever, to set one up. It's not worth it at this stage. We haven't got the funding. Let's just drive forward. But part of the problem comes is if the business does succeed or launches successfully, they don't then go back and sort out a proper agreement. And if you don't do that, there's 2 things. First of all, a proper agreement is going to be helpful in setting down what you agreed. But secondly, you don't even think about what you're agreeing, because you never have a meeting of minds. You never have you never sit down and discuss, well, my expectation is to work for 5 years, and then I might want to exit, or I might want to do this, or what happens if someone dies, or what happens if someone wants to go part-time in 2 years' time, and all these sorts of things lead to a position where where somebody feels that the other's taking advantage of them 2 or 3 days down the line. And it's not necessarily the case this is malicious. It's simply the case that they didn't have actual matched expectations at the outset. They didn't discover this because they didn't sit down and talk about these points. They didn't talk about, the exact roles, matters of control, what income was going to come out but to each of them, how an exit's going to be handled, how do you resolve issues? And if you set out those things in not necessarily even a very long agreement, or if you just agree them and put them down, then you're in a much better position if these can come to pass, because the default position is basically it's a bit of a mess. And I suppose you can say if there's a dispute between shareholders where there's no shareholder agreement, how does it ever get resolved? And it's really, the court does have some inherent jurisdictions of unfair prejudice as well under the Act, but it's very expensive, as Andrew said, to try to prove all that. And what it tends to mean is everyone's flinging muck at everyone else to try to put themselves in the best light, and that can often lead to a significant breakdown of relationships and indeed failure of the whole company. And no one apart from the dispute resolution lawyers is happy, because all the money's gone down the drain. And that's why having a shareholder agreement, or at least agreeing the main areas that are dealt with in shareholder agreements beforehand at the outset and getting it down in writing, is such a good idea for small and medium-sized businesses. I don't know.
I think that's 100% right. I mean, my experience is there's lots of business owners who've never heard of a shareholders agreement. It's not something that's on their radar at all. But I think of it as providing certainty between the business owners at the outset. You know what you reach in for, so to speak, and it's and it's sort of in a dispute resolution way. It's a bit like a prenuptial agreement in a sense that you come across in matrimonial matters, not me, but family lawyers, and in which you are. As part and parcel of the agreement, you're agreeing what happens when you leave. Now, there's lots of business owners at the start, they don't want to be thinking about the end and leaving, and because it's all jolly and happy and they're making money at the start. But it always makes sense it's certainly in small businesses that are a little bit like a partnership, to at the start agree what your respective rights are and how each of you will exit and what you'd receive when you exit. Because if you don't, then that's when you start getting into the big ticket dispute matters, and you end up on my desk because there isn't enough certainty in what you've agreed. And so we are, as Andy alluded to, he mentioned something called unfair prejudice petitions. That's where it's usually a minority shareholder will say that they have been unfairly and prejudicially dealt with in the company, and that the court should make an order that their shares be bought out. And then it's up to the court if it gets to it. And hopefully for all those listening, you will never have a matter that goes one of these matters that goes all the way to the court, because you will have paid a very, very substantial amount of money by that point. But it is at that point that the court will say how much somebody should receive, and then have to deal with who's liable for all the costs that have been incurred in getting there. Much, much better, while everybody's on great terms at the outset, to sit down and just have a moment where you say to each other, this is how we're going to run this company. This is the benefits that we're going to get from it. This is how we will deal with matters if things go wrong, or when people leave, or when people die. And the very process of talking through those matters can lead to so much more certainty for the business owners, and can be really, really beneficial, I think, for the businesses just going forward at the start. So this isn't something where you're just getting an agreement that's signed off, sits in a cupboard, and somebody might think of it in the future. It can be far more constructive than that. It can be really the people agreeing between themselves exactly what you're going to do, recording it, and to an extent protecting against doomsday scenario if everybody falls out and and everybody wants to have a dispute. Because if it gets to a dispute, if there is a shareholders agreement, then my first port of call is to look at it and see what it says. And if it's clear in its terms, that's what will happen. That's what the court would enforce those terms. It makes it far less expensive, far more certain as to what might happen. If you've got nothing, then no agreement, nothing in the Articles of Association, which Andy mentioned, which are the documents that underpin a company when you set it up. If you've got nothing in either of those, nothing of that nature that you can rely on, then you're for the court to try and work out what on earth should happen with your company in a dispute situation, and you really don't want to be left in that scenario.
Yeah, Andrew's 100% correct there. A lot of the time we have clients come to us that, often they've been referred by their accountant saying we need this agreement. They've got no idea why. It's quite sad, really, that, it's not sort of common knowledge, really, the importance of not only the shareholders agreement, but also the Articles of Association as well. They are the constitution, the foundation of the company, and they should really set out exactly what, all the parties want going forwards, really. As Andy mentioned, obviously it does protect majority shareholders. Obviously he said about minority shareholders, but majority shareholders, it protects them as well, because you can add tag along, drag along rights, which mean that the minority shareholder can't necessarily just be a complete hindrance and stop a business sale. They can't ask for an obscene amount of money just in order for, if there is a third party interested and they want to get out. That could cause, quite a lot of issues down the line. It does also protect the average company. I appreciate you said about companies that take off, but also the average company. If you just want to get out the company, you start as best friends on really good terms, but later down the line, you might have difference of opinion, see the company going in different directions, and you just want to get out. It's not always as simple as just saying, I want to get out. It can become quite a costly and time consuming part, really. It can be quite difficult, and obviously it leads to a lot of tension, a lot of stress. And if you've got a shareholders agreement in place, that would set out the procedure and make it a lot easier from the outset, so everyone knows they're all on the same page and know which direction they're all going in.
I mean, we usually, when people come to us and ask for a shareholder agreement, we usually send them almost a checklist for them to go through, because it asks the questions about the business that we need to know to draft it effectively. What sort of things are we asking? What sort of things actually go into a shareholder agreement then, Lauren, when you're actually drafting?
Well, it's intended to be a bespoke document, really. So it involves the members, shareholders, thinking about the nature of the business. So you've got to think about what matters should be reserved. So are there specific things which require the consent of a certain percentage, the majority, 75%, 80%, maybe just 50%? What kind of things should be decided upon by the vast majority of people? That's always an important one. The actual structure itself, it might just have ordinary shares. There might be different share classes. And if there are different share classes, then it leads on to the income point. Dividends, how are they going to be paid? Will they be paid just to one class of shareholders or all classes? Will they be paid monthly, yearly? There's things like that to consider. You've also got the board level. Who's making the decisions? How often are they meeting? What happens in the event that there are just, say, two directors and both they've both got different opinions? What happens then? You're in a deadlock situation, and if you've not got an agreement which sets out what's going to happen, you're going to run into quite a lot of problems there. You're just going to be at loggerheads, and it's not ideal. You potentially want to have someone with a casting vote, the right to maybe appoint a third director, or externally have a third person who can, for example, an accountant, a solicitor, who can help in that situation. So yeah, they're important things. As I mentioned earlier, you've got drag along, tag along rights, which will impact upon the shareholders in the event that there is a sale, that they tag along or they drag along. Basically, that's where the origin of the word come from.
So that means that. Sorry, that means.
So basically, that would mean that in the event that a third party sale is going ahead, that you are forced to ultimately sell your shares on the same kind of terms as have been offered to the majority shareholder.
That's a drag along.
That's a drag along, yeah.
The tag along.
And tag along is obviously they've got where if you've been asked to buy your shares, they buy the minority as well on the same sort of rights. They've got the right to be asked to sell the shares as well. There might be deemed exit provisions which are important. For example, not everyone thinks about it, but obviously you've got death, you've got mental health issues. If you've not got the ability to make decisions, or if you exit the company, whether you're an employee, consultant, if you've made bankrupt, certain things like that, you might want to have the automatic exit provisions where if that happens, your shares will automatically be sold and you'll be removed as a director. If you are a director, a lot of the time it's difficult to remove a director if there aren't actual provisions in a shareholders agreement or the articles which prescribe that. And also there's another common thing, which is the restrictive covenants, which Andrew, I'm sure, will explain in further detail, which are the post sort of termination restrictions which are imposed upon shareholders when they exit a company.
When you mean exit, though, that usually, I think most listeners will know about restrictive covenants on employees and employee contracts, and usually they can run for sort of 6 months or so, can't they, nowadays, as a maximum, to stop employees effectively competing with you or stealing your customers away for the 6 months after they've left employment, if they've been in a particular position that would allow them to do that, if they're senior employees. And you tend to expect those sorts of things. And the provisions in shareholder agreements look similar, but are slightly different because, first of all, they're not that their trigger is not when you leave employment, but when you cease to be a shareholder, which, of course, depending on the exit provisions, may be further down the line, or not at all if you're not forced to sell at that point. And I suppose the other situation is that because theoretically you're being paid out for goodwill and not just losing your employee status, you're being paid on an exit. If you're being paid a fair value for your shares, then by definition, very often there'll be an element of the ability of the company to make future profits that's in that valuation, a goodwill element of that valuation that you're being paid. And as you're being paid for goodwill, the courts are more likely to enforce covenants for a longer period than they would for a mere employee. So you might find that you can get 2-year plus bar outs in these sorts of agreements and be valid, whereas you're never going to get a 2-year buyout under an employee restrictive covenant, even though the wording will be very similar and the things you can and can't do will be very similar.
I think from my perspective as a disputes lawyer, is obviously when things get to me, everybody has fallen out. And quite commonly, it won't be much of an issue as to who's to go and who's to stay. The big issue is how much will be paid for somebody's shares. And a shareholder agreement can obviously help with that by providing a mechanism by which that person's shares may be purchased. So you've got some certainty as to the process that would be followed because it's been agreed. And if there isn't such certainty, if you haven't got a shareholders agreement, what's the position then? You may ask yourself. I mean, if you don't go down the route of drawing up a shareholders agreement, then my advice would be, whether you're leaving, whether you're staying, you take legal advice as soon as possible. And try and ensure that the other parties take legal advice as soon as possible. And hopefully you will then have early correspondence between solicitors to try and resolve things sooner rather than later, without legal proceedings, and let everybody move on, get on with their lives, get on with their businesses. Within that mechanism, it's possible to make offers that can have significant impact on these disputes, where you can put very, very considerable pressure on your opponent to settle with you, and basically have a mechanism by way of introducing a third-party accountant or valuer, where if everybody doesn't cooperate, then that can have significant cost impact within litigation. So I would certainly employ or suggest that anybody who has a shareholder dispute, as soon as possible, takes advice. Because I suspect taking advice at that point will save you money in the long run, or should do if parties cooperate with each other to try and negotiate a settlement. Also, on my side is, as Lauren alluded to, sometimes shareholders' agreements will tell you how you go about resolving it. And it may talk about going to mediation, for instance. Mediation is a great way of trying to resolve these sorts of things at an early stage at not too much cost. The other bit that I would mention from my own experience, which fits in with, I think, what they're saying is, or the others are saying here, is that if you take on a new shareholder, make sure that new shareholder agrees to adhere to the shareholders agreement. I have seen situations over the years where there's an argument about whether the new shareholder is bound by the shareholders agreement. Document it. It's a very short little thing, a couple of pages long at most. Get the person to sign up. They agree before they take up their shareholding that the same provisions apply to them as provide to the original shareholders, if I call them that.
I think one thing I was going to say actually is again about the trap of pushing the button on long form precedent. When you're acting for a small sort of quasi partnership or a small medium enterprise that isn't a mega corporation, that doesn't have endless funds to spend litigating, often lawyers will press the button and get a shareholder agreement. It's quite a long form document as a basic precedent, and it nearly always includes bad leaver and good leaver clauses. Now, the problem commercially with bad leaver and good leaver clauses is that unless they're very one-sided, unless basically it's just you're a bad leaver unless we tell you you're a good leaver type thing, or unless you die. If there's any sort of nuance or argument about what a bad leaver is, if you've breached a duty or not done X, Y, Z, if it's left vague, then all that happens is that the party wanting to exit wants to say they're a good leaver, and the board or the other shareholders want to say they're a bad leaver. And if there's any scope around arguing about that, then it just encourages people to argue. It encourages it. I'm quite a fan, and have been for some years, of sort of almost like no-fault divorce type scenarios. Whereas if someone's been a quasi-partner and worked for 3 more years in the business, then at that point they just exit at fair value, without a discount, or with perhaps a slight discount if they decide to be the first one out. And that's reflected in the shareholder agreement. And they don't. A shareholder agreement shouldn't encourage people to enter into dispute. A shareholder agreement shouldn't really encourage, on exit, the parties to actually start slinging mud at each other. And that unfortunately can be, if you've got a badly drafted good leaver, bad leaver type scenario agreement, that can be the risk involved in that. And they're very, very common because in the very, very long form documents, they're the standard sort of things that you see. So you have to bear that in mind as well. If you've got good leaver and bad leaver provisions, that itself can fuel lots of arguments. It may be easier just to agree, look, they've put whoever it is has put their years in. This is what we agreed was fair for them, and therefore this is what they're going to come out with. And that's really clear. It doesn't really matter then, unless you can show really genuine damage, fiduciary breach, fraud, that sort of thing. Unless you can show something like that, then you're not going to be, there's not going to be no benefit in trying to throw mud, so you won't bother on an exit. And that perhaps is worth bearing in mind if someone puts a long form shareholder agreement in front of you with all sorts of good leaver and bad leaver provisions in.
And on that point, I suppose transfers is an important one to consider, really, because you don't want to dilute your shareholding necessarily. So often you will want sort of a preemption, really, right, which in the event that someone is selling the shares, you either want to be able to have the right to buy back the shares yourself, or, if it's permitted under the Companies Act for the company to buy back the shares. And in that way, it doesn't dilute your shareholding. or have an impact, or, you know, if that's not possible, you do want to be able to have maybe some input on who the shares are transferred to. You know, a third party, you want to, you know, almost want the opportunity to vet that third party and make sure that you do actually approve of them becoming a shareholder. Because at the end of the day, you know, if it's your business, it's going to have a big impact upon who the new person coming in is going to be.
Yeah, I mean, for tax reasons, if somebody exits, it's often better to have a share buyback if the company has sufficient distributable reserves, just because it's much more tax effective. Effectively, if although the rights will be to transfer usually pro rata to the other shareholders that aren't involved in the exit, and therefore they keep their relative balance and proportion of shareholdings, which I think what you're talking about in terms of diluting the proportions. People don't often want to use taxed funds, their own tax savings, to buy out if the company's got the cash, and it obviously adds an extra layer of cost on to have to get the monies out tax paid as income or capital distribution or whatever to enable them to then buy the shares of the exiting individual. So it's fairly common that the shareholder agreement, or certainly shareholder agreement or articles, should provide for, if the board so decide, instead of there being a transfer to the other shareholders under the shareholders agreement, there's a buyback of shares in the company, which obviously proportionally has the same effect. So if there's a 20% shareholder who has their share and there's 100 shares in issue, if the shares are bought back, there's then only 80 shares, but the proportions of the other shareholders obviously are the same, kept the same. So that's the usual mechanic that's used in those agreements. So you'd expect to see some sort of share buyback option at the board's discretion if there was sufficient profits in the company to do that.
One thing I think it might be worth talking about is something that I see, which is that everybody starts a business off. They may even sign up to a shareholders agreement that's going to provide that. Say there's 3 or 4 of them in the business who are running it or owning it. 3 or 4 of them commit to being 100% involved in the business. As time goes on, you find that one person or may do very little. One person may be effectively running everything, and they get disgruntled because they look at what they're receiving and they think it's not fair as compared to others. So, and that can lead to disputes, that can lead to litigation. So I think one thing that might be helpful to discuss is what should that person seek to do to avoid a dispute? Now, the obvious answer is talk, isn't it? You've got to be open about people and say you're not happy, that there needs to be change. But and that can involve, I think, looking to change the shareholders agreement, to change the structure of who gets what, because you might do what I called a prenuptial agreement at the outset. Those terms may not be quite right when you're looking at it 5 years in. So I think that, and it's a difficult conversation, I would imagine, for somebody to have, but something that's good. If you could agree a revised shareholder agreement that keeps the business going, keeps everybody working together, keeps everything on track, then those discussions, that amended agreement is going to save you an awful lot of money if it avoids a full-scale shareholder dispute. And I think somebody said to me when I was that at some point in this discussion I should give some indication as to what that sort of cost of those disputes can be, and certainly they can easily run into hundreds of thousands, I'm afraid. As I said earlier, they are notoriously expensive. So everybody, I would implore everybody who's or might be involved or thinks they could end up in a shareholder dispute, to not bury your head in the sand. If you're being moaned at because you're not maybe contributing enough, then you can't just bury your head in the sand. You've got to. Companies, shareholders, directors should talk and try and resolve things themselves without lawyers, but perhaps record them in maybe an amended shareholders agreement, whatever it may be. But be proactive, absolutely proactive to resolve it without the need for a litigation. That's a bit of a ramble, but there we go.
I think that's an excellent point, is that the reality is that things change and you do see resentment as one of the main drivers of shareholder disputes. And another classic example of resentment is where someone's put some funding up to launch a company, to launch a business, but isn't working as much or at all in the business, as perhaps a passive shareholder of 10% or 15 or 20%. And initially, the business required that money and was critical to the launch of the business. But after 4 or 5 or 6 or 7 or 8 years, everyone else is working really hard, and the other person may not be maybe passive or working 1 day a week or something, starts to really resent the fact, and that build-up of resentment really is best foreseen. There should be some sort, in some scenarios, if there's a funder there, you should think about preventing that resentment, because it's better to have a smaller slice of a happy and growing pie than have all the other co-directors decide they'll go up and set up on their own, or just not worth it because you're being parasitic on them. So that there's a danger around that as well, assuming that you can. I was dealing with a shareholders agreement discussion last year, where the existing partners had built up a very strong business of existing shareholders, and they wanted to pass it on down the generations to the next generation of an MBO. But their idea was that they just they'd give some shares to the MBO team, and the MBO team would take over and run it, but then they'd just keep the majority of the shares themselves and sort of sit on a beach up when they're 75 and not doing anything. And I had to explain that wasn't really realistic, because in reality, if 2 people have taken over and are running the business and you've retired effectively, they're not going to be happy giving you 75% of the profits forever. It just isn't going to be. You might have a buyout at a point where you get some money, but you have to eventually appreciate that in sort of quasi-partnership businesses, if you're not actually contributing work, then people are going to start resenting you, and that's the driver of all these.
And you will end up with a dispute at some point. I mean, almost as night follows day, particularly so when so many small businesses start out with such a special relationship between the people who are doing it. I mean, they're often very good friends, the sort of shareholders' disputes are very much like a divorce, really. They can be very, very bitter indeed if they're not resolved sooner rather than later, and that just involves a bit of bravery, really. Being brave enough to say to somebody, look, we need to sit down and talk because I'm not happy. And to not take offence to somebody who approaches you in that way, to think, right, this is a business. I'll listen and see if I can resolve. And that's certainly what I would recommend people try to do. Not easier said than done sometimes in the hostility, but it certainly is the preferred course of action. If you can reach a mutual agreement with advice, mutual agreement that is best for everyone.
So I think the takeaway points really are communication is key. Obviously at the start, but also throughout the process of the company growing, developing, getting a bespoke shareholders agreement in place and articles that match that and complement it, and also in terms of the shareholders agreement, really having those discussions early on and thinking about your exit. Obviously you're at the start of the company, at the start of the development of the company, but one day exit is inevitable. You will want to get out, so think about exit, think about income, dividends, how's that's going to work. Think about the reserved matters and what sort of percentages and things should apply, and also think about the restrictive covenants. So obviously, you spent so long building up this business, you don't want someone to leave the company and a month later set up their own business, which competes and takes away all the staff, takes away all the clients, customers, whatever. As you say, it's friendly to start with, but unfortunately it doesn't always end that way. So just to think about, really sit down, have that initial thought process and just get some kind of agreement and document in place so you're all on the same page and you all know what each other's roles are, what's expected and what's going to happen in the future, so far as you can, really.
I think it probably makes sense for me to say something about restrictive covenants in this context. in that I do like to see in shareholders' agreements restrictive covenants at least considered. Now, what are they? They come in all sorts of different forms, but one perhaps I'll just focus on for now is the ability for somebody to leave, set up a competing business round the corner, and you will often get covenants written into shareholders' agreements that say that shouldn't be possible, that's not fair, and that's what shouldn't happen. And I think one thing you've got to be, in terms of that sort of thing, it is sensible to take advice on restrictive covenants, because they'll only be enforceable by a court if they're reasonable, and are reasonable at the point that they were entered into. So what is reasonable at the point they're entered into? Well, that may vary from time to time as the case law on restrictive covenants develops. For example, many years ago, or some years ago, a time period of, say, a year might have, applying to a restrictive covenant, might have been reasonable. It may not be now. So it is, I think, sensible to take advice on the wording, the length of them, but they are, without question, something that should be considered at the outset.
Another point just to discuss is key man life assurance. So this is basically insurance which is taken out by the company to cover potential consequences if a key member of the business should die. Obviously, this is more common if there's kind of just one or two members involved in the actual company itself. And the policy will provide for the value of the deceased shares, which will then be paid to the company to allow it to buy the shares back. Now, Andy, I know obviously you're quite well versed in cross options and things like that. So in terms of cross options...
Yes, I mean, well, the key, the kind of, you can have key man taken out in the name of a company, but again, for tax reasons, it's often more usual for there to be the personal agreement between the individual shareholders. So a life. So if there were two shareholders, Lauren and myself, in a company, and we wanted to protect each other against the death of one, you'd have a situation where Lauren would enter into an agreement to put it basically to ensure my life, or the company would pay for it, but then the benefit of that would be held in trust for the other co-shareholders, so for Lauren. So if I died, the other shareholders, in this case Lauren, would get that money, but she would have entered into a cross option agreement with my spouse, or with me and my estate, that my estate could call on her to buy the shares, and she could also call on my estate to sell the shares. And you might be saying, why don't you just simply have an agreement written down that on death, the deceased estate will be bought out, full stop? Why mess around with all these cross options? And the reason why something's more complicated than it needs to be in a document is not unusually because of tax. And it's quite a big one. And if you ever want to make if you're trying to make a homemade shareholder agreement, this is a big trap not to fall into. Which is that for trading companies, most trading companies, the shares of them or their holding companies are exempt from inheritance tax on death because of something called business property relief, which currently is 100%. So 100% of the shares of a company are not subject to inheritance tax, and the public policy reason is you don't want companies broken up and sold to pay tax to the government, because people get, companies employ people and people lose their jobs because of the tax obligation. So the idea is that the trading companies the shares in them, you don't pay tax on them. But, and it's a really weird quirk, if there's a contract in place at death for somebody else to buy those shares, then what the estate actually has is a debt. It doesn't have the shares anymore. And because it has a debt for tax purposes, that does fall into inheritance tax. So if you've got shares with £1 million, don't say that they will be bought out on death by the other party or by the company. Say you have to enter into this agreement where there's a cross option, where one party has the option to buy, the other party has the option to sell. And in that way, effectively, of course, they will be bought out on death, but it's not actually certain legally, and therefore it doesn't trigger this debt problem, and you don't lose your business property relief, and you don't have to pay 40% inheritance tax on £1 million out of your estate if you die. Usually this is dealt with by way of standard policies that all the life assurance companies have. So rather than putting cross options into shareholder agreements, although I have done in the past, you just have a provision whereby you sign the standard cross options and trusts that hold the benefit for the other shareholders in place, etc., provided by the relevant life assurance company. It's usually quite a good idea to do that. The decision you really have to make is whether you say that the price is a fixed price, which you then have to keep updated as the value of the company increases, or whether you say this is a contribution to a price, but the actual price is market value, and that's determined by the firm's accountant or whoever. And in which case you need to be careful that there could be the gap needed to top up if the insurance policy isn't enough to cover that market value price. But generally they're quite good ideas quite good ideas, and you can get quite cheap insurance. It's quite tax effective. The company can pay for it, set it against profits, and it's worth looking into if somebody dying would critically damage your business, which is likely in a fairly tightly held company. Unless there's anything else, I think I'd like to thank Lauren and Andrew for their contributions, and I hope that you've managed to stay with us and enjoy it, and learned a little bit about shareholder agreements today. Thank you very much.
Thank you.
Cheers, thank you.